justice to handle our issue urgently. We pray for that. Thank you, Mr. President.
Thank you very much, Fatima. I didn't know women can do this job.
Yeah.
Thank you very much. And that's a very good testimony and example and model for our young girls and young women. To invite you and to give you the honor of being the first person to speak at our Radical Nuba Live, which we hope will be a weekly place, forum for press and public engagement. And in all honesty, you've done justice. You've spoken for all Ugandans and your colleagues. I would like to invite my treasurer, Mr. Arthur Isiko, to give our response to all your able submissions. I specifically sought out Mr. Arthur Isiko because the business of bailiffs goes to the heart of advocates' revenue, advocates' resilience, and advocates' representation. You are in charge of the end of the river processes for whatever we start. You are in charge of keeping the Lord Mayor alive over a career of more than 20 years. Those who are starting to practice law, I hope you can share the pain. Mr. you can please come. You came with your daughter last time. And your wife, are they still here? She's at school. But your wife is here. Please come for the world to recognize you. Please. She's just a court baby. Let's take it. Thank you very much. Thank you very much. You can introduce yourself, our member.
Rules Committee etulwako chairman nga ye Chief Justice. Einako Attorney General. Einako President wa Law Society. Einako Director wa LDC. Einako ne Principal Judge. Chief Registrar abeeranga Secretary waayo. Naye abantu abo bonna nga bwe mbogedde baatuula ne bakola etteeka. Etteeka lye baakola tebabeera guided by the constitution. Irwiru yabaguidinga. Irwiru zina gwe nkyogera mu Luganda. Irwiru yabaguidinga nga baagala just kupanisinga babeiriifu. Bakikola tebategeeza nti baagala graduatinga babeiriifu. Naye bali baagala kubapanisinga. Kati nabo kibatuddemu lwa nsonga. Lwaleero ennaku z'omwezi 16 terina license yafulumye. Bitandise okubeekubyagana bokka na bokka. Amateeka geekubagana n'abantu. Nabo tibalina engeri gye bafulumya license. Kati saawa eno kaakati tewaliwo beerifu alina license. Kubanga nabo tebalaba teeka lye bagifulumizaamu. Etteeka lye baafulumya January 22, 2022. Si lye baateeka ate mu gazeeti. Mu gazeeti baasimagolingayo lirala. Kati amateeka abiri gakontana. Kati nabo bibatamye bibalemye. Naye twali tusaba President wa Law Society atuyambe nga bw'atuula ku kakiiko ako atuuse eddoboozi lyaffe kubanga ffe Chief Registrar yagaana okutulaba, Chief Justice yagaana okutulaba. Twakola petition wa Chief Justice, President agendako kopi yagaana ogiddamu. Ne tukola ey'okubiri n'agaana ogiddamu. Ne tukola petition 2 mu Constitutional Court. Constitutional Court erina mandate egamba bwe wabeerayo petition ya constitution ereka emirimu gyonna n'etunula ku eyo. Naye kati myaka 3 tetuulanga kutunula ku gundi eyo. Ne tubawandikira amabaluwa ne tubakolera buli kimu kyonna ebintu bigaanye. Kati ne tulaba Radical Nuba eyinza kutuyamba ne tujja ne tugituukirira etuyambe. Mukama waffe President tuli wano ku maviiviigo tweyanziza.
Let's allow this to Uganda Speaker but it can try. I thank you so much.
For the purposes of Luganda media, I want to give highlights in Luganda. Basebo ne banyabo nga babeirifu beba wanyondo ba koti.
Yes, in the past court bailiffs were riffraffs. Today it's the reverse. We no longer have riffraffs. We have intellectuals who went to school. Now, my understanding is this is becoming almost a general phenomenon that in every corner of Uganda, at least one or two people are complaining about judiciary. Me, I'm not complaining. I'm only begging the Chief Registrar to listen to us. The Chief Justice to listen to us. The Chief Registrar refused. Fine. Well, at least let the Chief Justice listen to us. This is what we are begging. We are on our knees, by the way. We are begging. We don't have an alternative. We are brought to understand this country belongs to some people. We agree. But today we are begging, please listen to us. Me, I have behind me about 6 or 10 people, plus my friends. Everybody has people behind him. So if you say you are sending away 300 people, in the nutshell you are sending away about 3,000 people from school and other related issues. Mr. President, I know with your style of work, you are going to help us overcome this.
Them has raised the issue that they are in breach. They are in breach of a cardinal duty to resolve the Kabaziguruka appeal promptly, now that the public honestly has reached breaking point. The public's patience has reached breaking point. It is my humble submission, colleagues, that we have reached a point where open, relentless, and severe criticism of Chief Justice Owinidolo and his Supreme Court can no longer be avoided. Their curious and culpable delay on the Kabaziguruka appeal alone has eroded and continues to erode trust in the judiciary, perpetuating a culture of impunity and disregard for the rule of law. Due to their delay in delivering this judgment, our Supreme Court luminaries are now perceived as enablers of military repression of political opponents, stifling dissent and perpetuating a culture of fear. Why don't they listen to what the public thinks of them now? Isn't that a breach of Article 126, Sub-Article 1, that they sit in those offices in our name and they perform their duties based on our trust? So our perceptions of their fidelity matters. The Law Society has, which has received your petition. Your petition comes from even a position of privilege. It can be written. But for the Karamajongs, we have to pick intelligence and data from conducting retreats with our staff, and we ask them, what weren't you able to do? And they say we couldn't. get Karamajongs, hundreds and thousands from the dragnet of Masholo. We don't have the resource. We don't even know where to begin. It is therefore crucial that our meeting with the Chief Justice, when it happens, and I hope he doesn't cancel it now because we have spoken. But we hope that when it happens, it should result in one thing and one thing only, a judgment date in the Kavaziguruka appeal. He was giving an interview in the Monitor recently, and he said the characteristic of justice is to act without fear. But why does he fear? Isn't this fear? One wonders, what do the Supreme Court judges fear? Why are they pussyfooting, dilly-dally? And whispering over there to ensure that his colleagues on the Kavaziguruka decision, the Kavaziguruka quorum, comply with Canon 6.2 of the Uganda Code of Judicial Conduct. And this has undermined the principles of fairness, of justice. Justice must not be delayed. Justice must be speedy. Finality of litigation. We are talking of 25 years, 42 justices of the Supreme Court and Court of Appeal reaching endless and chaotic decisions on just one provision, the PDF Act. The ordinary citizen is confused. Is Uganda incapable of pronouncing with clarity the laws Parliament has written, the Constitution it made for itself? Why do we pay these people? Why do we continue to pay them if they cannot serve us? The sole product and service we want from them, justice. Now, we are aware that the justices of the Court of Appeal and the Supreme Court are in retreat in Imbarara, where they have been since Monday the 13th, and they will be there until tomorrow the 17th, to discuss appellate court business, I would presume, and welfare, of course. Chief Justice Owinidolo, when he was Deputy Chief Justice, in that regard, including sitting on public holidays,
sitting on weekends, public holidays, even at night, as they did.
On the occasion. In contravention of Section 7 of the Judicature Act, which implores the Supreme Court to invoke as much power as lower courts have in conducting business before it, Rules 20 and 21 of the Supreme Court rules. Rule 20 says the Chief Justice solely is in charge of the business of the Supreme Court. He determines what gets done, when, and by whom, and where. Solely. He's the sole business manager in the Supreme Court. When he says the ruling shall be delivered not later than this date, every judge must obey. And we saw what he can do to those who don't obey him. We saw, and we know. It is Rule 20. Rule 21 says the Supreme Court can sit in vacations, weekends, when it determines that expedition is required. The power is in the rules. Rule 10 of the Constitutional Court Petitions and References Rules is even more clear. It says where constitutional matters are involved, and I think I heard you, Mr. Ramkaga, and your delegation speak to it. Was it Mr. Baguma? Rule 10. You remember the words of Rule 10? Yes. Created, as you said, my Lord Mayor, a chilling effect that silences critical voices and perpetuates a culture of fear and repression. When 23 lawyers resolve that the matter is beyond them now, they must hand it over to the radical new bar to lead from the front, because it can no longer be resolved through private client briefs. The agency of advocate-client autonomy has been exhausted. You have a duty to the public and to the society to report the limits of your capacity. You have done that. And we have received it in the name of our ancestors, and in the name of those living and the name of those to come. Mr. Elias Lukwago walked here on the 16th of January 2025 and declared that enough is enough. Enough. He had reached the limits of his capacity, and he handed this over to lawyers past, living, and prospective to take on. Vicariously affects us who intervened. I am a good example. I can talk about this without crying. I have clients whose testicles have been cut off, nails have been pulled out. The things we have seen, you cannot unsee. We worry about hiring younger people like Gwen in our farms because we shall damage them through work hazard. So this work, at this point I should say, it has damaged our colleague Ladislas Rakafuzi. He opened extended hand to everybody, and he suffered massive stroke before even he was 60. He's now, we are taking care of him. Speaking of trauma and psychological distress, I cannot stress enough that the Karamoja region in particular has suffered greatly because its communities have been displaced and marginalized due to military actions against the alleged Karashunas. The military is conducting expeditions in Karamoja that you do not even have an idea about. Shoot to kill, mass arrests, screening. The most recent example was pictures on social media which shocked the Committee on Human Rights in Parliament because youth were starving in Gulu prison. They had been marched from Moroto, Kabong, Abim to Gulu prison, where you can't have visitation and everything, and they were fed on water and sprinkling of beans and posho whenever it is desirable to do so. Did you see those pictures? Well, you're lucky. They were swept out of the internet, so you can't see. Now, they are in their tens of thousands. And this is just in the last 2 years. 2,000 were released to go back home. So if 2,000 are known cases, how about the unknown cases? Contrary to Articles 28, Sabbatical 1, which speaks of a speedy hearing as a fundamental right. No court has business. No court has a power, a right or duty to conduct its business through delay. The standard is speedy. Contrary to Article 126, Sabbatical 2, Clause B, principles of justice. Justice shall not be delayed. It's emphasized twice in the Constitution, in Articles 28, Sabbatical 1, and Article 126, Sabbatical 2B of the Constitution. Contrary to these clear, simple provisions concerning how the judiciary must be exemplary, above all constitutional organs, the top court's excruciating delay has emboldened the military to intimidate and harass advocates, journalists, and human rights defenders who dare to speak about these violations. Or say that, of course, the first time the matter was heard, 2 justices died. My Lord Justice Ruby Oil, and villages, children. Subsequent cases, what I call post-Kaihura cases, after the reign of terror of Kaihura, the Constitutional Court had a change of mind. The warnings that lawyers had made immediately after passing of the Act, there was now a body of evidence. And here we must thank Makerere University, especially Dr. Nalwairo, who insisted on collecting the data at the General Court Martial, getting data from the General Court Martial. It has been his lifetime work to create a body of evidence that the General Court Martial is not a fit and proper place for civilians. He is now the principal of the School of Law. Previously, he had done this work through the auspices of the Human Rights and Peace Center. It wasn't the Law Society collecting this work, this data. Our members have tried, but our data is scattered in various habeas corpus applications like Namgerwa's. At least Ladislas Wakafuzi took the matter to the highest court. Most people stop at the High Court. After all, these are the poorest of the poor that we deal with. Other people can call. They have someone to call. Somebody is missing. So, subsequent cases after Namgerwa have progressively sought to resolve this pressing issue. Let me canvass them for you, Honorable Lord Mayor, and for Gwen and other Gen Zs to understand. After a 5-year delay, Constitutional Petition 45 of 2016, Honorable Michael Kabaziguruka versus Attorney General achieved a favorable ruling by a majority of 3-2 on the 1st of July 2021, declaring an end to civilian trials in military courts. Unequivocal. On the 15th of December 2022, that's a year after the Kabaziguruka decision, another decision which had been gathering dust in the Constitutional Court for 7 years was decided. Its name is Constitutional Petition number 44 of 2015, Captain Emon the General Court Martial. These are civilians who they have served sentences in excess of 7-10 years. They are saying still we are here, there's no other chance for us to get out of this system except a constitutional interpretation. That interpretation came after 7 years. Most of them had left, had served sentences and left. Some are still there, although their sentences are completed. You know this. By a majority of 3-2 in constitutional petition 18 of 2005, the appeal from that issue was abandoned by Uganda Law Society. Our hands are tied. As a result of the Namugerwa decision, the military has continued to try civilians, leading to arbitrary arrests, detention, and torture. Most people here are so young to remember the reign of terror of Kaihura, where there is a high-profile murder, villages are circled up, profiled good Muslim, bad Muslim, and detained in the General Court Martial. I don't even know what he's doing at the General Court Martial. He caused this error. They are the same. They are the same. Maybe that's why he doesn't want to appear there. But he knows. David Mpanga must know that he abandoned Mr. Dule when Dule needed him the most. And that's why we are here. The Supreme Court, those days when the Supreme Court was still a Supreme Court, could have resolved this issue on the 20th of January 2009, possibly prohibiting the military from continuing to try civilians. But we have had this problem with us for 16 years simply because young lawyers abandoned a senior lawyer to go and make money and hang around and truck around town doing commercial and corporate commercial nonsense. Now we are here. On the 19th of June 2013, in Supreme Court Civil Appeal number 4 of 2012, Namugerwa Hadija versus DPP and Attorney General, the top court avoided addressing this constitutional question. It had arisen during an ordinary appeal from the denial of a habeas corpus order in the High Court. Namugerwa Hadija had moved the High Court judge for the release of her relatives who were held in the General Court Martial. And her plea was simple. Through her lawyer, Ladislas Rakafuzi, they have no business holding these civilians. That detention is unlawful. And the procedure for making that argument, as you all know, is called a habeas corpus application. The High Court judge refused to grant the habeas corpus order, ruling that no, Section 119, subsection 1, clause G and H, permit the military courts to hold civilians and handle them. So that detention is not unlawful. I reject the habeas corpus application. Senior Counsel Kafuzi immediately applied to the Court of Appeal, and the Court of Appeal of those days had him immediately. So the appeal from the High Court was heard that year by the Court of Appeal. It agreed with the High Court judge, and he appealed immediately to the Supreme Court, and it had him immediately. So all these proceedings happened in 14 months between 2011 and 2012, and they gave him a judgment. saying abandoned the ULS in 2008, but he returned to assist Kabaziguruka register success in the year 2021 before the Constitutional Court, and he has this time not abandoned Kabaziguruka. I saw him in July last year completing the circle, walking the Lule walk, ensuring that the appeal from Kabaziguruka is argued by him just as he had argued below, or even much better. And he has done excellently. He has addressed almost 3 panels which have been reconstituted, as you know very well. So, Mr. Segona has done well to repair his reputation and his account. He's in good standing with the bar. As for them, this is where we are. The initial challenge, Constitutional Petition 18 of 2005. 2005. So this act was passed in September, 2nd September 2005. Do you know who moved first to challenge this particular provision? It was the Uganda Law Society. In September of that year, the Uganda Law Society challenged Section 119, subsection 1, G and H of the UPDF Act in CP number 18 of 2005 versus the Attorney General. It resulted in a split decision by a majority of 3-2 in favor of upholding the constitutionality of prosecuting civilians in military courts. In Constitutional Appeal number 1 of 2006, the Uganda Law Society had filed a cross appeal. So which means that the Uganda Law Society challenged the UPDF Act extensively. It challenged so many provisions, not just this one. And it won on all those provisions except this one. So the government appealed on all the other provisions, and the Uganda Society filed a cross appeal on this particular issue and another issue, which again is important for you, trying civilians jointly with the serving officer. So I'm here to tell you, colleagues, that we are sorry. Our ancestors abandoned the cross appeal on this issue when Constitutional Appeal number 1 of 2006 was called. In the year 2008, I was a clerk then, a research clerk to Justice Katrebu. I witnessed the representative of the Uganda Law Society say those words. I abandoned the cross appeal on those grounds. I will name names. He was Senior Counsel Godfrey Rule. I accosted him at the exit and I said, why did you abandon that ground? Honorable Lord Mayor, Senior Counsel Rule told me, look at me, 79 years old. I have defended the appeal of government on almost 47 sections. I had no energy left in me to argue the cross appeal. When we began doing this case, Mr. SEMAKADDE, there were many young lawyers and senior lawyers with me. That was 2005. In 2005, there was a caravan of lawyers with me. Look around the court now. Who do you see? He asked me. I said, we are together. So he said, now section 119, subsection 1, clause F, clause G, and H will be for your general Your generation. Tutango we. Remujoku yiga. Now, it is important to name certain names. In Constitutional Petition 18 of 2005, the record shows that Mr. Lule led a team accompanied by David Mpanga, Frederick Kisitu Mpanga, and Medad Segona. They were absent when Constitutional Appeal 1 of 2006 stand up to help him complete the circle. It is no coincidence that Medad Segona fought ruthlessly to win the Kabazigiruka case to purge his conscience of his absence when Constitutional Appeal number 1 of 2006 came up. It is no coincidence. And we celebrate him for correcting his error. Please, take our gratitude to your partner. Take our gratitude to justices in the Court of Appeal and Constitutional Court of Uganda, as well as the Supreme Court of Uganda, have spent a total of 25 years examining whether this section is inconsistent with Articles 28 Sabbatical 1, 126 Sabbatical 1, and 210 of the Constitution. In simple terms, 42 justices of the Court of Appeal also sitting as the Constitutional Court of Uganda, and the Supreme Court of Uganda, the top court of Uganda, have taken 25 years of legal time examining one question: whether the trial of civilians in military courts is unconstitutional. Think about that. 25 years is the median age here at the Uganda society. So, you saw Gwen, before she was born, the judges were examining this issue. Now she's giving me advice as a member of the Rule of Law Department. And the judges are still examining this question. There is an interesting book for those of you who love literature by Charles Dickens. It's called Bleak House. Anybody who knows it and you get 100,000 shillings. Bleak House. It has an interesting opener. The case of jaundice versus jaundice. Judges have come and gone. Lawyers have come and gone. But the case of jaundice versus jaundice remains at preliminary stage. It was supposed to be about a simple issue. Who should benefit from this estate? Generations of the original beneficiaries have since passed on. But the record records adjournment after adjournment. No witness has ever been heard. You must understand now, if 200 years have passed, which witness is there to be heard on the original question of the will of the jaundice estate? On some day, which is still being discussed, someday soon, possibly this month, I believe next week, I will lead a delegation, a high-level delegation of the Uganda Law Society to meet the Chief Justice of Uganda, Honorable Alphonse Chigamoy Owinidolo. This time on behalf of countless individuals and families whose lives have been torn apart by the lack of clarity on the legal framework governing military courts. This matter has plagued our justice system for nearly 2 decades, resulting in egregious, the worst form of violations of fundamental constitutional rights, and it demands immediate redress. The time for action is now. The Uganda People's Defence Forces Act, almost now well known as the UPDF Act, which commenced on the 2nd of September 2005, included Section 119, subsection 1, clauses G and H, which have been the subject of endless and chaotic interpretation by the judiciary of Uganda. This is what the UPDF Act provides in the aforementioned section. 119. Persons subject to military law. The following persons shall be subject to military law. G. Every person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense. Now, a person ordinarily subject to military law is a serving military officer. So this section 1G says that every person other than a serving military officer who aids or abets a serving military officer in the commission of a service offense will also be subject to military law, or what my senior colleague has called martial law. And H, every person found in unlawful possession of, item number 1, arms, ammunition, or equipment ordinarily being the monopoly of the defense forces. And item number 2, any person found in unlawful possession of other classified stores as prescribed. That, in essence, is section 119, subsection 1, clause G and clause H. Now, this petition you have presented this morning, which, as you correctly stated, was brought to our attention earlier on in some form by the lead counsel, Honorable Martha Karua, who we had the chance to meet as part of our consultation process at some point during your proceedings. It's sad that we can't have her here to present it herself, but you have done it justice. She covered almost similar ground when we met her, shortly before bedtime, one of those days you were in court at her residence. So, we have received another petition from the International Bar Association, the Human Rights Institute. And we have received similar calls from the Regional Bar Association, the East Africa Law Society, and concerns. I am in communication almost daily with the President and Vice President of the State of Kenya to ensure the safety of their colleagues who are performing in Uganda. Behind Honorable Martha Karua, I understand there's a team of jurists, not only from Kenya but across the world. And the proceedings at the General Court Martial have been of great concern for the International Commission of Jurists, which is housed in Kenya, the Kenya chapter. So this is not the only petition the society has received, and we are open to receive more petitions, and we assure the public that we will give these petitions treatment, the rightful treatment they deserve. Welcome you back, Governing Council, Mr. Vice President and Mr. Treasurer, for your service today, as well as our colleagues who are online, council members for Eastern, Western, and Northern Uganda, who couldn't join us on short notice because they'll be joining us for important council business in the new week, over the weekend as well, actually. I would like, in a special way, to give gratitude to our secretariat team, led by Ms. Christine Awori.
Eyingira mu nsonga zino nga bwebadde ng'ejja erwanagana n'ensonga zino okumala ebbanga okulaba nti olugendo luno tuluggusa olw'okuteekawo embeera ey'obwenkanya. Mu General Court Martial gye tuli, Mr. President, teriiyo bwenkanya. Environment yonna oba embeera eriyo ya busibira mu bbwa, ya kututwaliriza tuwerekere Dr. Besigye ne munne ku kalabba, kubanga emisango gye baba bagguddeko singa gibakka mu vvi etteeka ligamba gyakubatwala kalabba. So bwe tulaba ebigenda mu maaso, buli ka application konna ke tuteekayo, buli nsonga yonna gye tuteekayo bagikasuka mu kasero. Kooti ne banne bonna, chairman ne banne batutunuulira nga ffe abatalina mugaso. Ensonga zonna ze tuteekayo ez'amateeka ziziimuulwa buziimuulwa. Kakati kyatuuse ensonga zaalinnyo enkandago bwe bwagijja bagidde nga Bya Kizza munnaffe bamukutte ne bamuyisanga ekyonziira ne batamala namuwozesa, naye ne bamuteeka mu komera ekitalya okumala emyezi 9 ng'ate etteeka lya PDF Act liga nti maximum sentence eyinza kuba ya nnaku 3 nga tawozeseddwa. Kakati waliwo embeera ey'okutiisatiisa balooya, era okusooka twali balooya 42, kati we tutuukidde wano tusigadde 23, nga ttiimu y'abalooya abamu batiisiddwa, abalala bakooye ne bagamba ebyo bya General Court Martial tebigasa. Mr. President, nze njogedde ne ba senior lawyers bangi nnyo nga bagamba nti eyo tetukyadda, ffe eyo tetukyadda mu General Court Martial. Mr. President, nange nali omu ku abo abaali bateekinze decision nga nti mu General Court Martial sikyadda. Naye kati kino bwe kyatuuka no tugamba nti nunno katugende tuteekewo olutalo olulaba nti wabeerawo obwenkanya. Kati kyakusaba Mr. President ne executive kisooka Bya Kizza bamulanga bwemage yali akola mulimu gwe nga looya, era ne bamukwata mu mbeera efaanana bwe tuso. Okusaba kwaffe kwakuga nti Law Society ejjeyo n'ag'omu buto okulaba nga tujja muganda waffe Bya Kizza ekitalya gye bamuteeka. Ekyokubiri ekisembayo kwe kulaba nti Mr. President buli kyonna ekisoboka tukikola nga radical new okugamba nti ekimala nti enough is enough. General Court Martial teri waggulu w'amateeka, teri waggulu wa ssemateeka. Naye kati yo
kyekola eragira ddala nti yo ssemateeka tagikwatako. Obuwaayiro bwonna bwe tusayitinze obuli mu ssemateeka ebusuula eribbali bakwata bukwasi UPDF Act ne regulations zaabwe. Ssemateeka tabakwatako, tewali nnyingo ya ssemateeka n'emu gye bakwatako. Bo ssemateeka bamufuula ng'ekipapula. So tugamba nti buvunaanyizibwa bwaffe nga ba lawyer era kwe kusaba radical new bar ogamba nti tukube ku mmeeza, kube emmeeza okulaba nga wabeerawo obwenkanya, wabeerawo enkola entuufu eri mu ssemateeka okulaba nti general court martial ekomya byekola kubanga ffe kyetugamba era kyetulemeddeko Mr. President ba civilians oba abantu ba bulijjo balekerawo okutwalibwa mu general court martial. So awo bwe kiba kisoboka okuba emmeeza okulaba nga ba civilians abantu ba bulijjo tebaddamu kutwalibwa mu general court martial. So lwe lutalo ssematalo lwe tusaba Uganda Law Society okulemberamu. Tweyanziza tweyanzeeke.